I finally decided to do a video on Pennsylvania versus Mimms. It's a 1977 U.S. Supreme Court decision that basically applies Terry v. Ohio to traffic stops, specifically related to ordering a driver out of the vehicle. Doing this now because there's a video that I watched recently that made me think of this case again. I'm going to show it at the end of my short presentation as a case study. But first, this is a discussion of legal theory. When you're pulled over by the police, it's not the time to argue theory. You may be able to beat the rat, but you can't beat the ride. So play nice. The facts of the case were, first, police performed a traffic stop on a car in Pennsylvania with an expired plate. And second, the officer that did the stop had a practice of ordering all drivers out of their vehicles as a matter of course whenever they had been stopped for a traffic violation. The court applied those facts under Terry v. Ohio to see if a police officer, after a valid traffic stop, could order a driver out of the vehicle without violating their Fourth Amendment rights. The court's holding related to search was that the additional intrusion can only be described as de minimis. The driver is being asked to view very little more than is already exposed. And then as related to seizure, the court's holding was that the police have already lawfully decided that the driver shall be briefly detained. The only question is whether he shall spend that period sitting in the driver's seat of his car or standing alongside it. What is at most a mere inconvenience cannot prevail when balanced against the legitimate concerns for the officer's safety. Under Terry v. Ohio, the Fourth Amendment analysis is always the reasonableness in all the circumstances of the particular governmental invasion of a citizen's personal security. Reasonableness depends on a balance between the public interest and the individual's right to personal security, free from arbitrary interference by law officers. So right away, Pennsylvania v. Mimms has a very specific fact pattern in that the police officer, in this case, would order people out of the car as a matter of course. So if a police officer doesn't do that at the majority of their traffic stops initially, and as a matter of course, Pennsylvania versus Mimms isn't going to directly apply. Although the case could be cited to argue that the proper analysis of whether a police officer can order a driver out of a vehicle against a different fact pattern is a Fourth Amendment reasonableness analysis under Terry v. Ohio. The justices found that the public interest under Terry v. Ohio was really as to officer safety. Two different officer safety reasons were mentioned in the holding. First, according to one study, approximately 30% of police shootings occurred when a police officer approached a suspect seated in an automobile. And second, the hazard of accidental injury from passing traffic to an officer standing on the driver's side of the vehicle may also be appreciable in some situations. I'm underlining in some situations because by using those words, the court is admitting that this hazard of passing traffic won't apply to every traffic stop. And then here my poor graphic skills show the driver shooting at the officer as the officer approaches the vehicle's driver's side. Pew, pew. What the police officer should probably do is take cover behind his door and order the driver out of the vehicle from a distance. Most police don't do that because they're usually not ordering you out of your car because of safety. Can they really argue safety issues of standing on the driver's side of the door if they choose to approach the driver's side instead of the passenger's side? An important thing that the justices don't seem to take into account is the safety of the driver from traffic, too. There is an important footnote in Pennsylvania versus Mimms that says, "We do not hold today that whenever an officer has an occasion to speak with the driver of a vehicle, he may also order the driver out of the car. We hold only that once a motor vehicle has been lawfully detained for a traffic violation, the police officers may order the driver to get out of the vehicle without violating the Fourth Amendment prescription of unreasonable searches and seizures." So the footnote isn't just saying we applied the reasonableness test and determined that these specific facts made it not a Fourth Amendment violation. Instead, it's saying as long as the vehicle was lawfully detained in the first place, so the police officer pulled them over for a valid traffic infraction, the police officer can automatically order the driver out of the car without violating the driver's Fourth Amendment rights. In the case law, though, this footnote is currently being disregarded, as it should. If you look at all the citations to Pennsylvania versus Mimms, and there's close to 5,000, that are just mentioned in Lexis, there's a lot of them that say that the case is distinguishable because the police officer in our instance did not have a habit of, nor did he immediately order the driver out of the car, but rather ordered the driver out at a later point in the stop. The police officer doesn't implement a policy of always ordering drivers out of the vehicle, then Pennsylvania v. Mimms does not apply. Either another case must be used, or one must conduct a reasonableness analysis. The video we're going to look at next happens in Edmond, Oklahoma, with that city's police department. So here's the relevant law that I want you to be aware of while you're watching the video. In Oklahoma, unlike in most states, the police can arrest for traffic infractions that occur in their presence, but misdemeanor arrests can only be made before 10 p.m. Note that the event in the video happens after 10 p.m. though. The resisting statute in Oklahoma applies when a person knowingly uses force to actively oppose an officer in the discharge of any duty of his or her office, and also the officer must have probable cause and authority to arrest. I say authority because if it's after 10 p.m. and the police are trying to arrest someone for a misdemeanor, the officer does not have authority, so a person can resist without breaking the law. Probable cause is a slippery slope because the officer is going to claim he didn't have the statute memorized, and that a reasonable officer could have thought that there was a violation of the law, even though clearly the statute doesn't support it. The obstruction statute in Oklahoma applies when a person knowingly delays an officer in the discharge of any duty of his or her office. We also have to weigh this against the Edmond Police Department's policies. Although the Oklahoma state law says police can arrest for traffic infractions as long as it's a misdemeanor and it happens before 10 p.m., the policy says traffic violations will not routinely result in an arrest, but violators may be arrested for refusing to sign citations as it presents a failure to appear risk. The police in Edmond shouldn't be arresting people for traffic violations. If they do arrest someone for a traffic violation, automatically it's going to be looked at as retaliation because they're arresting someone but typically exercise the discretion not to. If the person is exercising their rights when arrested, then it's going to look even more like retaliation. This is the textbook definition of civil rights retaliation. Regarding use of force, an officer should use de-escalation techniques and other alternatives to higher levels of force consistent with training whenever possible and appropriate, before resorting to force and to reduce the need for force. Although you'll notice the Edmond police wrote this using the word should, so an officer isn't required to use de-escalation techniques. It's in their discretion based on their feelings. Lastly, violations of internal policies forms the basis for disciplinary action. A lot of times when an officer goes at you and wrongfully arrests you, there's just no fair fight in the legal system due to probable cause and qualified immunity. But if they've violated a policy, make sure and make a complaint. Maybe you can get them written up. You can also use those policies to show retaliation. All right, so here's the video.
On September 17, 2022, an officer with the Edmond Police Department in Edmond, Oklahoma was on patrol when he saw a silver vehicle with a broken third brake light.
So right here is the first interesting thing. The narrator says broken tail light. As you notice here in a second, though, that's not what the police officers are saying.
The 39-year-old driver, Brandon Riles, turned into a parking lot, and the officer activated his emergency lights to conduct a stop of the vehicle. The interaction that followed was captured on the officer's body camera.
How you doing?
Pretty good.
Where's I'm pulling you over, your third brake light's out.
Right there, the police officer says it's out.
My third brake light?
Yeah, the one of the... Yeah.
No, it works pretty good.
No, it doesn't.
So right here, whether the officer has done a detentional traffic stop in order to investigate whether an infraction has occurred, or if the police officer believes he has probable cause to arrest, the police officer is still required to look at exculpatory evidence provided. Here, Mr. Riles says, "No, it works pretty good." That's when the officer should be conducting additional investigation. Instead, he says, no, it doesn't.
Huh.
See your ID, please?
I don't have one.
Okay. You don't have one at all?
I haven't violated anything per the First Amendment, so I'll need to show you ID. You actually stopped.
Now, this is a traffic stop. Why is the police officer asking for ID? An officer should ask a driver for a driver's license and pedestrians for ID. especially in Oklahoma, that is not a stop and ID state where the police can't demand a non-driver for ID. Why aren't you always asking for a driver's license when you're stopping drivers? Could it be because the police are so well conditioned to try to get consensual access to IDs from non-drivers? Anyway, if one was to be a pedant, Mr. Riles has his amendment number incorrect, but he is correct that he doesn't have to show ID. He is legally required to show his driver's license, though, which is not the same thing. Assuming that the police officer has pulled him over for minimally the suspicion of a traffic infraction, he should show his driver's license if it's demanded. Here, the police did not even request his driver's license. Note that if the officer pulls Mr. Riles over for the suspicion of or probable cause for a non-traffic crime, the officer could not technically demand to see his driver's license, even if the driver's license would prove the crime. Although he wouldn't have to show his driver's license, Mr. Riles would be required to identify himself by providing his name and date of birth.
Up there, then when I pulled in here, then you pulled me over. So I've been reporting this
587,
all the
can
time.
you start me another?
Yeah, go ahead and start another unit.
Okay, your third brake light is out. And perfect enough, my supervisor's pulling up.
All right, that's cool.
Cool.
Thank you.
So you have no ID on you. Are you refusing to identify yourself?
I don't talk to the police, sir.
Now, the police officer is asking Mr. Riles if he's refusing to identify himself. If this is a valid traffic stop, then Mr. Riles would have to identify himself if the police officer demanded it. Here, the police did not request him to identify himself. Mr. Riles answers that question great, though, not admitting or denying that he was refusing to identify himself. Now, it is possible here that Mr. Riles himself is confused here and thought that he didn't have to show his driver's license and wasn't just looking for legal loopholes to prevent from showing it. If he actually believed that he didn't have to show his driver's license here if demanded, he would have been wrong, although this is a common misconception. Mr. Riles mentions that the police didn't light him up until after he'd stopped in a parking lot. This is not an issue, though. The police have privilege to do a traffic stop in a parking lot or even a private citizen's driveway, including the citizen's own driveway, not in the garage, though. Also, the statute of limitations is generally 365 days for a traffic infraction. The police could wait up to 364 days before they let you up and cited you. However, you probably would not be expected to have your driver's license on you if they waited until you had left the vehicle. They'd also have a harder time proving that you were the one driving the vehicle.
Okay. Well, easy enough. Go ahead and put your car in park for me. It's in park? Okay, cool. Huh?
That's your method.
It's good. All right. Go ahead and step out of the car for me.
I'm pausing it here so you can see that the third tail brake light is not out. Perhaps the plastic cover is broken and it's not showing red or amber, but it's hard to say because the police just say out. It looks lit up to me. At this point, it seems more likely that Mr. Riles was pulled into the parking lot. The police followed him in, saw that he was black, and decided to light him up under the pretext of an out third brake light. Also, the cop has just asked Mr. Riles to go ahead and step out of the car for me. Mr. Riles appears to be driving a truck, not a car.
No.
Okay. So this is how this is going to go, okay? I have a legal right to remove you from the vehicle.
How?
It's case law from the Supreme Court.
No, it's not. Sir,
It 100% is. You are being pulled over for. You've been pulled over for a traffic violation. Can you please let me finish?
So the police says, I have the legal right to remove you from the vehicle, and it's case law from the Supreme Court. He's probably talking about Pennsylvania versus Mimms, but is he correct about having the right to remove Mr. Riles? Perhaps he means that he can order Mr. Riles out of the vehicle if he has a legitimate need that outweighs Mr. Riles' right to personal security, free from arbitrary interference by law officers.
Dude, I've been recording this whole time.
You have a third brake. Hit your brakes. Hit your brakes.
So he seems to be doing another investigation. Good job. It's hard to know the results because the video is cut here. I'm assuming it's because it makes the police look bad, maybe?
Are you refusing to exit the vehicle?
Yeah.
Okay. If you don't exit the vehicle, I'm going to place you under arrest, okay?
For what?
For resisting, because you're not following my...
arrest?
Yeah, because I'm giving you a legal... I'm giving...
Now, if you're asked if you're resisting, you should never say yes, which Mr. Riles did, but this is ridiculous. The police tells him he'll be arrested for not exiting the vehicle. The statute the officer is citing as the basis for that arrest is resisting arrest. So the police officer is going to arrest him for resisting arrest. It's circular logic. Is he resisting arrest? What was the basis for the arrest that he's resisting? So it's just getting worse here. The name of this video, as you see in the upper left, is Legal Expert Turns Traffic Stop into an Arrest for No Reason. I think the narrator is probably referring to the driver to give him a hard time, especially given how the narrator rates the interactions accordingly at the end. However, I think the title could more likely be describing the police officer because he's the one that thinks he's a legal expert, and spoiler alert, turns the stop into an arrest for no reason. So let's discuss the law here. The police officer does have the authority to order Mr. Riles out of the vehicle, but it's the authority granted to him by state statute and not by Pennsylvania versus Mimms, the same statute that allows the cop to investigate and arrest. Technically, this is an equipment violation and not a traffic violation, but same thing. All the cop needs is for the traffic stop to have been the result of an actual traffic infraction or crime, and the officer needs to have weighed public interest against the rights of Mr. Riles. The cop probably doesn't even have to explain his analysis. However, how is the cop going to get Mr. Riles out of the vehicle without some convincing and explaining his analysis? Through reasonable force, right? If the search and seizure analysis results in the cop being able to order a driver out of a car, he can only use a reasonable amount of force to get the driver to comply, under Graham versus Connor. The Graham factors are 1. The severity of the crime at issue. Here, the severity of driving with an out third brake light would not authorize any use of force. 2. Whether the suspect poses an immediate threat to the safety of the officers or others. Here, the dude is just sitting in his car smoking a cigarette. The police have not acted in any way to show that they fear for their safety. And 3. Whether the subject is actively resisting arrest or attempting to evade arrest by flight. Here, dude is just sitting there. His vehicle seems to be boxed in and the vehicle is in park. Sorry, but using force to get Mr. Riles out of the vehicle is simply not going to be permissible in this case.
Giving you a legal
What am I
order.
resisting arrest from?
I'm giving you a legal
Private
order.
property. What am I resisting arrest from?
Okay. I'm giving you a legal order
I
to
just pulled
exit
into
this
the parking
vehicle.
lot and then you pull me over.
I'm giving you a legal order to exit this vehicle.
Do you think the police officer repeating, "I'm giving you a legal order," in a louder and louder voice is helping? The officer is making legal conclusions. He's not explaining anything. Is it working to de-escalate the situation?
The officer informs Mr.
All right, so here is where the narrator correctly says that Mr. Riles is probably not guilty of resisting, but rather obstruction. I'm skipping that part. If the police officer actually was able to order Mr. Riles out of the vehicle, then yes, Mr. Riles was obstructing. Excuse me. There are a couple issues, though. Was the third brake light actually out? And what was the officer's need to have Mr. Riles exit the vehicle?
illegal traffic stop, and that consequently an individual could be convicted of obstruction for refusing to comply with officer commands during a traffic stop that was later held to be illegal. In reaching this conclusion, the court argued that, now I'm quoting, "The typical motorist simply is not equipped to make a determination of whether there is a legal basis for a traffic stop, and that the issue of whether an officer has probable cause to make the traffic stop, now quoting again, should be resolved in a courtroom, not in the streets. Accordingly, even if a court determined that the underlying traffic stop was unlawful, it is still likely that it would conclude that Mr. Riles violated the obstruction statute by refusing to exit the vehicle."
All right, so this part I have to disagree with. After reading that case, it doesn't seem factually relevant. Mr. Riles was not resisting the detainment of the traffic stop, such as fleeing, like in State versus Nelson. He was maintaining the status quo and had not resisted being detained. If the police were to provide a valid explanation on why they needed him out of the vehicle to perform their duties, and then Mr. Riley refused to comply, then Mr. Riley would have knowingly obstructed their duties. Unlike resisting, obstruction doesn't require an active role. Unfortunately, that's not what happened, though.
I'm giving you a legal order to
parking lot.
It doesn't matter. You committed a traffic violation on the road.
Any traffic violation.
You have a third brake light out. That is a traffic violation, an equipment violation. You can step out of the vehicle right now,
I don't
or
have
you will
to.
go.
I do not have to.
Are we getting
sir.
another unit over
That's
here?
my First Amendment right.
Okay.
So
You
I
obviously
pulled into
don't
the parking
understand
lot.
how the First Amendment-
I stopped in the parking lot. Then you turned on your lights. How are you doing, sir?
Good.
This officer is failing horribly at de-escalating and has made no progress in actually requesting a driver's license, proof of insurance, and registration, nor has he done anything to move forward the citation of Mr. Riles or his alleged equipment violation. The supervisor's coming in now. Let's see if he makes things better.
So you just turned on your lights when I was in the parking lot.
Okay.
So I have a First Amendment
It's
right.
a traffic stop.
For what? I was already in the
An
parking lot.
infraction
then you
based
turned
on the
his lights.
roadway, sir.
Say again, sir?
An infraction that happened on the roadway.
No, that's not what happened. I pulled into the parking lot, then he turned on his lights.
That can
near
work.
a drinking establishment. You guys saw me pull over here. So because I missed my turn, then you turned on your lights after I pulled into the parking lot because I missed my turn.
Right.
Now all of a sudden it's all this whole thing. So you're trying to violate my First Amendment.
That's not what's
now,
happening
I
here.
recorded the whole time.
Your First Amendment's a freedom of speech, sir.
So First Amendment, Fourth Amendment, et cetera, et cetera.
Go ahead.
I like how he recovers from that. He was referencing the wrong amendment, but he's like, rights are rights. You knew what I meant. The supervisor at least speaks calmly, but he also sucks at explaining their authority to cite Mr. Riles. Additionally, the supervisor does nothing to move forward with that citation.
So I do not have to.
So you don't think your third brake light's out?
I don't think it's out.
If you guys are going to be pushing like this,
No,
I would recommend that I ask for a supervisor.
This is a supervisor.
I'm right here, sir.
He's a lieutenant.
All right. So if what I'm saying isn't resonating with y'all, I'm going to ask for you guys to call the FBI.
No.
Okay.
Yes,
Here,
straight up.
Listen,
Their
sir.
number
Listen.
is 297. It's
Listen.
not hard.
Listen. He stopped you for a traffic violation.
Sir, yes, sir.
Okay.
That's what you're saying, yes, sir.
That's what
No,
I'm
I
saying.
pulled in here, then he turned on his lights.
That's fine. That's a traffic violation.
No, I was
It's a traffic.
here.
Listen, you're
No,
not.
sir, I
Listen, I'm
pulled
trying to
in,
explain to
then
you, sir.
I stopped, tried
Sir.
to reverse, and then he turned on his lights.
Okay.
Look at how my vehicle's positioned versus y'all's.
Okay, listen.
Period.
You're not listening whatsoever. You just keep wanting to talk over everybody. Okay. He had a traffic stop conducted on you for a traffic violation that happened on the roadway. That's perfectly legal, perfectly fine.
No,
He's
sir.
asking you to step from the vehicle.
The cop messes up here, I think, and says that the officer's asking him to step from the vehicle. Makes it sound like an optional request.
I had pulled into the parking lot, then he turned on his lights.
Okay.
Period.
Okay, we've explained it now.
I don't think they
Is
explained
Bob
it.
all working tonight?
No.
We've
Does he still work for
we've
Edmund?
explained it a few different
No,
times.
no. Period.
Okay, we
That's
could
the
just
law. You guys are trying to violate my rights.
Okay.
Mr. Riles argued.
Right, here the narrator goes into the statute related to a third brake light and case law related to initiating traffic stops in a parking lot. We're going to skip over that part.
Third brake light.
Go ahead and step out.
No.
Okay. Well, you're under arrest. Okay.
So they finally told him he's under arrest. Now they should explain to him that they need him to exit the vehicle so that they can take him into custody and warn him that if he uses force to prevent his arrest, that he'll be in trouble for resisting. Although one can lawfully resist an illegal arrest, one probably shouldn't, especially if that person is black. Now, if he's been unable to get the cops to look at his exculpatory evidence, he should probably just cooperate. In addition, when a police officer takes someone into custody, especially after you've frustrated them, they're going to use an intermediate amount of force to effect that arrest. You are highly likely to have a knee in your back, and if there's more than one officer, more than one knee. And it's unfortunately legal to always use some force, even if it's not necessary. So if you're not a healthy person and can't handle that force, make sure and start sharing your medical needs, such as injured shoulders or back. If you have the opportunity, before they say you're going to be arrested, you should lean up against the hood of their car with your hands behind your back. They should then handcuff you there and you won't get a knee in your back. You know when people can't breathe while being restrained, it's from being on the ground, usually with some weight on them. There's been a lot of new legislature to protect us from police force. Some states now have laws where if you say you can't breathe, the police must immediately get you medical care. The case law and new chokehold laws say you're most protected from excessive force once those handcuffs get on you, too. So don't let them beat you up while they take their time putting the handcuffs on. Actively work to get those cuffs on you as soon as possible. If you get banged up, make sure and let them know because they are required to get you medical aid. Let's see how this arrest goes.
I'm not under arrest.
Get out of the car. Get out of the car.
I'm not getting out. You guys are violating. Hey, you can't just
Get out of the car.
my truck.
Get out of the car. Step out of the car.
Step out.
Step
Hey,
out of the car.
Step out. We're gonna force you out if you don't.
Step out of the
Don't
car.
ask him. I'm not
You're under arrest, sir.
Whoa, easy, fellas.
for me. There you go. You're good now.
There you go. All right.
When Mr. Riles refused.
The cops do a better job than most here. They ordered him out maybe 8 times before they physically remove him. I don't see how any of the de-escalation mentioned in their policy though. And then, so here the narrator does a crappy job of analyzing the excessive force, but he still gets to the right conclusion.
Constitute excessive force.
Are you gonna stand up and walk to the car? We
Yeah,
need to carry you.
whatever you guys need.
Well, that would have been helpful like 5 minutes ago, sir.
I've been pretty reasonable the whole time.
No.
Here, hold on. My shoulder's caught under your chair right here. Yeah, just tear the shirt there.
Well, if you don't
Here, I got you. I'm stuck.
There we go.
I'm stuck on your chair. Body.
So we saw them carrying Mr. Riles. In some states, it's illegal to passively resist arrest like that when you go limp and make them carry you. But it's not legal in Oklahoma. They then lay him in the car on his stomach, which is a violation of a lot of chokehold laws now. I don't know if there's one in Oklahoma yet against that. They also intentionally tear his shirt to drag him into the car. It appears to be as punishment for having to load him in the car that way. So the last part is just going over their gradings of everyone. So they gave the police officers an A-, which I think they didn't earn, maybe an F-. And then they gave Mr. Riles an F. I think he probably should get a C. The misconceptions that he had are pretty common, so let's do C for common, aka A average. That's all I got for you. Thanks for tuning in. Bye.